Hey guys, lawbyreece here with another video, and I'm starting out, guys, here on Thugger Daily. This is a trial that I've been watching uh, news and commentary on and watching parts of the trial for a few weeks, guys. I'm a licensed attorney here in the state of Texas. I've been licensed since October of 2022. Since I got out, I've practiced in civil litigation and criminal defense, currently specializing in criminal defense. I opened up my own law firm, Ringnauld Law PLLC. If you want to learn more about Ringnauld Law, feel free to shoot me an email, guys. Only if you are in the state of Texas. I am not licensed to provide legal advice in any jurisdiction other than the state of Texas. If you are in Northern Ireland, we'll try and find you help in Northern Ireland, but I cannot help you in Northern Ireland. Okay, guys, so if you haven't heard about this trial, it's a RICO trial here in Georgia, State v. Jeffrey Williams and a number of other defendants, basically accusing them of committing organized crime that dealt in violence, drugs, that sort of thing. And this trial's been going on for many, many months. It's very much in the public's eye right now, and it's something that I wanted to read some of the motions and give you some of the commentary. Guys, first, before I do that, though, I want to give sort of thanks here to Thugger Daily. I also want to let you know that I've been watching this channel, Cat Not Williams. I'm not sure if she's an attorney or not. I don't think she is, but I don't know that for certain. But anyway, she's been following the trial as well. I like listening to her commentary, so big shout out to Cat Not Williams, and also getting some of the motions that we're going to read out together, guys. So this is from Thugger Daily, which is an X or Twitter channel here. Can see that he's not Euro Glanville's courtroom. Guys, before I get into this video, I do just want to comment that I am just naturally on the defense's side. I think that Jeffrey Williams or Young Thugs should be out on bond. I think that he's given reasonable bond conditions in his latest motions. I'm surprised that he hasn't been afforded bond, given that he is presumed innocent, not presumed guilty. And so personally, I think that he should be out on bond. But that's just my opinion, guys. I'm not here. I'm a pretty milquetoast commentator. I'm not here to really take sides, but I will tell you that I'm pretty biased on the defense side, guys. I like people's freedom. I like the Constitution, and I think that Young Thug should be out on bond. Okay, guys. I also think personally that from what I've seen, that number one, the trial should continue to be publicized because trials are meant to be public. I know that the state of Georgia wants to put in a gag order, potentially stop live streaming the trial, guys. I do believe in the publicity of trials. Trials should be public. I think that the stream should remain up. I also want to mention that I just think that defense attorney Brian Steele is something of a badass. I don't know how else to put that. I really do, and I really thought it was impressive when he said he wanted to go to the Cobb County Jail to work on the case with his client. I thought that was really admirable. So that was something that I was watching there. Okay, guys, so we're here on Thugger Daily. We're going to get our latest update, guys. This is from Thugger Daily on July 23rd. A ton of motions were filed today. Here is a summary of the most important pending motions. The deadline for responses for these motions is the end of the week. The new judge will hear and rule on these motions starting the week of Tuesday, July the 30th, guys. So I know that my camera is going to block out a couple of these. I will continue to read out loud. Okay, guys, so Young Thug wants bond. He wants a mistrial with no retrial. Disqualify prosecutors Love and Hilton. Strike all of Woody's testimony from June the 12th onwards. Challenge previous judge's ruling that the ex parte hearing was proper. Yak Gotti, I forgot what Yak Gotti's actual name is, but that's another co-defendant. And then he wants bond. We mentioned bond once. Mistrial with no retrial. Mentioned that. Yak Gotti wants bond. Mistrial with no retrial. SB, forgot his actual name. Mistrial with no trial. And reconsider Glanville's ruling allowing Woody hearsay to reach jury. Quay Nichols, mistrial due to issues as a result of a new judge coming in this late. Quay Huey? I'm sorry, I don't know. And then, guys, at the bottom it says the state wants, as in the state of Georgia, wants to forbid bad character evidence from the defense about a victim, and that's Nut. Again, I don't know their proper names, but that's another co-defendant. And then forbid the defense attorneys from speaking about the case in the media, which I just think is ridiculous. Okay, guys, so we're going to get through our first motion here together. This is from July the 26th, 2024, and I hope y'all can all see this. Okay, y'all should be able to see this, guys. Okay, so this was filed in the Fulton County Superior Court, July the 26th at 5:30 p.m. You can see in the Superior Court of Fulton County, State of Georgia, State of Georgia v. Jeffrey Williams, defendant, indictment number 22 SC 183572, Judge Whitaker. So Mr. Williams is the artist Young Thug. He's on trial now for RICO charges, which is the racketeering statute, organized crime statute, in the state equivalent in Georgia of the federal RICO statute. Mr. Williams's response to state's motion to restrict extrajudicial statements filed on July 23, 2024. Number 2, motion to adopt motion for fair and constitutional trial on behalf of Mr. Stillwell, as well as DeMonte Kendrick's motion for mistrial, both filed on or about July 23, 2024, and then Little Roman 3, notice of non-joinder of Mr. Nichols' motion for mistrial, an objection to mid-trial substitution of the trial judge, filed on or about July 23, 2024. Okay, guys, so this is coming from Jeffrey Williams' attorney, Brian Steele. You can see at the bottom here, Steele Law Firm, and that has his address, phone number. Okay, guys, so comes now Mr. Jeffrey Williams by and through undersigned counsel, who's Brian Steele, and hereby files this Little Roman 1, response to state's motion to restrict extrajudicial statements on July 23, 2024. 2, motion to adopt motion for fair. Motion to adopt motion. That's something. Motion to adopt motion. I'm motioning to adopt a motion. It's a motion to adopt a motion. Okay. I'm kidding, guys. Motion to adopt motion. I like that. Motion to adopt motion for fair and constitutional trial on behalf of Mr. Stillwell, as well as DeMonte Kendrick's motion for mistrial, both filed on or about July 23rd, 2024, and 3, notice of non-joinder of Mr. Nichols. Can I get this page view to be different? All right. We'll leave this as it is, guys. Okay. In the above reference case, so notice of non-joinder of Mr. Nichols' motion for mistrial and objection to mid-trial substitution of the trial judge filed on or about July 23rd, 2024. In the above reference case, in support of this response, Mr. Williams shows as follows. And then we have section 1. Mr. Williams is innocent of all crimes in the above referenced indictment. Okay, number 1, response to state's motion to restrict extrajudicial statements. And then we have little footnote 1 here. Footnote 1, as previously announced in open court on the record, undersigned counsel hereby rejects and objects to any proffer made by lawyer Love and or lawyer Hilton. And then we have a case site here, see State v. Shaheen, volume 370, Georgia Appellate 20, page 202, footnote number 2. Let's see. Volume 896, Southeast 2nd, page 23, and that's a 2023 case. Section number 2, on or about July 23rd, 2024, the state filed a motion to restrict extrajudicial statements. So what the state of Georgia is trying to do is trying to prevent Young Thug and the co-defendants, Mr. Williams and the co-defendants, from speaking about the case to the media. Now, before I provide this commentary, guys, I just want to state that these are all my opinions, and they're going to be pretty milquetoast or middle-of-the-road opinions. I am a practitioner, and so I don't want to take too strong a stances necessarily here on YouTube. But what I will say is that I'm wholly against restricting the public access to the trial. I'm not a big fan of restrictions on free speech. I do believe that the public has a right to watch the trial, and then I think that his defense attorneys have the right to go and plead their case to the media and to the public. And so I just think that the state of Georgia is trying to restrict his defense attorney's ability to sort of defend their client's honor or brand or image, so to speak. And of course, they're trying to silence the defense. So no, I'm not on board with silencing the defense. We have a First Amendment constitutional right to free speech. I'm sure that the state of Georgia has a First Amendment that mirrors the federal Constitution's First Amendment. We're supposed to have fair and open trials, and his defense attorneys, it's not like the defendants are going to go out there and speak to the media right now. They're in jail. So no, I don't agree with a motion to gag the defendants who are presumed innocent, and they are clothed in innocence until proven guilty, and that's how our system is supposed to work. I'm not in favor of gagging the defendants in this case. Now, I'm not a Georgia attorney, but that's just how I feel about that. Mr. Williams' counsel's statements referenced in the state's motion do not violate the plain language or spirit of any ethical rule. And I just happen to, I agree with that. My commentary on that is Young Thug's attorneys should be able to speak openly and freely, as is their constitutional right and as are their clients' constitutional rights. And they are presumed innocent. Presumed innocent. Okay? And so my feeling on the bond motions and then on this motion is that the state of Georgia has dragged on this trial long enough, and they've brought on 3 or 4 different judges now. I don't know how an argument can be made that this was a fair and constitutional trial, especially given the ex parte meetings. But now the state of Georgia is trying to gag the defense and the defense's ability to speak about the case to the public and to the media. That's not in the spirit of, I don't know the Georgia ethical rules. I really don't. I'm not a Georgia attorney. I don't even have the Texas ethical rules memorized. But my feeling, being pretty naturally pro-defense, is his attorneys should have the right to speak to the media about the case and defend their clients and put their clients in the best light that they can be put in. And no, I think that just goes against the presumption of innocence. Mr. Williams' counsel's statements referenced in the state's motion do not violate the plain language or spirit. And I think spirit is a good way to put that, just because the plain, not only do any ethical rules plainly state that the defense cannot speak with the media or something about media contact, but it's also not in the spirit of any ethical rule. I agree with that. Remember, this is Brian Steele, or Young Thug's defense attorney, writing this. In contrast, the state failed to alert this honorable court that before and during jury selection, when the potential jurors were not fully charged to avoid all media reports concerning this indictment, the following occurred. Number little 1, sub 1, Romanet 1. Fox 5 press conference with Fulton County District Attorney Fannie Willis, Esquire, dated May 10th, 2022. Then we have a link to that. I'm not going to click on that link. District Attorney Willis speaks from 11/21 to 19:07, from 20:37 to 21:23, and again from 22:19 to 24:18, including the following. And this is Cap A. So Romanet 1, Cap A. In reference to District Attorney Willis claiming her priority is to prosecute gangs, and there's a reason for that. They are committing conservatively 75 to 80% of all the violent crime we are seeing in our community. And so they have to be rooted out of our community. I just said a week or two ago, it does not matter what your notoriety is, what your fame is. If you come to Fulton County, Georgia, and you commit crimes, and certainly if those crimes are in furtherance of a street gang, then you are going to become a target and a focus of this district attorney's office, and we will prosecute you to the fullest extent of the law. We are proud to bring forth this indictment and hopefully to bring justice to a lot of the community who were victimized through the course you'll see in this indictment. But more importantly, the most important thing we are here to do is to keep this community safe, and we believe removing these 28 defendants will keep Fulton County safer. And then we see Cap B here from the reporter. These are some serious, significant charges. I would imagine you're going to seek some pretty serious sentencing here. I know it's early, but can you talk a little bit about the sentences they might be facing? District Attorney Willis will ask on the different charges for the maximum penalty, and there's obviously many people that are looking at life under this indictment. You're absolutely right. These are serious times. They're serious allegations, and it is my opinion that violence in our community deserves maximum penalties. All right, so I guess we have a real law and order kind of deal going on here. Cap C, reporter, how big is this gang? Is that a good portion of the gang here operating in Atlanta? And how long were you investigating them? District Attorney Willis, if you look at the indictment, the crimes that are alleged within it go all the way back from 2012 to 2022. I wouldn't say that it contains every active crime that YSL committed. It is a significant gang that operates here in Atlanta, Georgia. Not every member became a defendant within this indictment, but certainly a significant amount did, and certainly some of the leadership, which is what's most important. Cap D, District Attorney Willis notes that this investigation/indictment has been a long effort of the District Attorney's Office and reports on her conversation with Mr. Thomas's mother, a deceased in this case, citing her hopes to obtain her justice. And then Romanet 2. Below is a link to episode 3 of the podcast King Slime, the prosecution of Young Thug and YSL, released in August 2023 during voir dire and prior to jury selection. The podcast has since stopped recording episodes, but was hosted by music journalist Christina Lee and the honorable reporter George Chidi? District Attorney Willis made it clear that she cannot provide specifics of the case, however, shares the following. District Attorney Willis's segment from 818 to 1348, 1724 to 1926, 2015 to 2140, 2516 to 2710. All right, and it goes on from there. Cap A, 1737, District Attorney Willis. I remember when we first took office, we're screaming from the top of the top hills. I like that, top of the top hills. Not exactly sure what that means, top of the top hills, but top of the top hills. That there's a gang problem, and people were really actually kind of treating us like we were crazy, right? There's a gang problem in LA, there's a gang problem in Chicago, but they did not want to admit that there was a gang problem right here in Atlanta. But we kept talking about facts I knew to be true because I knew crime waves. I knew that one important person got killed, and we got a gang war for several years. 2015, reporter Chidi brings up the 75 to 80% statistic District Attorney Willis claimed at her initial press conference referenced above. District Attorney Willis, I think the stats that we're depending on are actually low. What we are talking about when we tell those numbers are self-identifying people that have already gone into the penal system, and they're identifying actually as gangs, or we're finding their mail or their phone, so we're not hitting a lot of people. The one thing that is unique about this group is it really doesn't count if you're in a gang if you don't claim it, right? So you'll find that even in police interviews where they'll tell you what set they're from, they're proud to declare it, or they have a tattoo on that says it, or through emojis. Through emojis, I guess. I don't know about emojis, but okay, emojis. Or through direct language on social media. So we're just talking about those that we know. So I guess she's saying in that interview that she didn't know all of them, and they speak through emojis. The gang members, they all speak through emojis. Okay, I'm sure that happens. I don't know. 3805 Cap C, District Attorney Willis. I hope that you know, for gang members, I am hated and feared. Hated and feared. Okay. Cause, I really think that should be a because, but cause I am not going to apologize for bringing gang warrants or educating the police on how to bring gang warrants and for prosecuting people that decide to get into that life. Cap D, 5032, District Attorney Willis. It's so interesting you talk about snitching because everybody hard, right? It's so interesting you talk about snitching because everybody hard, right? I I'm sure that there was a way that she said that it made sense at the time, but just in written form. Till they sitting in that seat. I've been doing, I already said, a very, very long time. I personally have tried, over 100 homicides, prosecuted hundreds of them because of pleas and other resolutions for cases. Literally, all I did for a very, very long time. She really likes her very. A very, very, and then a very, and then a very, very long time. When people get to sitting in that seat, more often than not, they snitching. I think we missed a they are snitching, or they will snitch. They snitching. They snitching. They snitching because the choice is life. Or you can tell what someone else did and what their involvement was. And so that's real cool to say on social media. But when it's you sitting in there and your mama and your woman, so your mama's in the room and so is your woman. They're both in there. Sorry. Your mama and your woman, you got a baby on the way. You got all these other responsibilities as a man you need to tend to. You got to make grown folk decisions. Grown folk decisions. For you and your family. And so often the decision is, I'm going to tell the truth and wrap this up for me. Okay. All right, so we get to section 3 here. So remember, guys, this was all a reporter interview between somebody and Fannie Willis. All right, section number 3 here. Lawyer loves motion to restrict extrajudicial statements must be rejected. It is rich, audacious, and hypocritical. Damn, I want the Oxford comma. Is it so hard to have an Oxford comma? I understand that everyone nowadays doesn't like the Oxford comma. And I'm the last guy here stating that I want to keep that Oxford comma. Okay, it makes a difference. I don't like that we've done away with the Oxford comma, and I'm going to file a complaint. Okay, I don't know to whom I'm going to file said complaint, but I'm going to file something. All right, and we're going to get the Oxford comma back. It is rich, audacious, and hypocritical. No comma. There should be a comma there. There is not. It is rich, audacious, and hypocritical that the state seeks to critique as unethical the single statement by Mr. Williams. I like that. Rich, audacious, and hypocritical. R-A-H. I like that. So Brian Steele wrote that. Rich, audacious, and hypocritical. That the state seeks to critique as unethical the single statement by Mr. Williams' counsel, which contains accurate, factual assertions. As an overarching principle, Rule of Professional Responsibility 3.6, Comment 1, makes clear that just like the framers of the United States Constitution envisioned almost 250 years ago, we need some more punctuation, Mr. Steele. Okay, just some more punctuation, maybe a dash. When they mandated that those accused of crimes are guaranteed the rights to a public and speedy trial. Quote, there are vital social interests served by the free dissemination of information about events having legal consequences and about legal proceedings themselves. The public has a right to know about threats to its safety and measures aimed at assuring its security. It also has a legitimate interest in the conduct of judicial proceedings, particularly in the matters of general public concern. Furthermore, the subject matter of legal proceedings is often of direct significance in debate and deliberation over questions of public policy. And that is quoting Rule of Professional Responsibility 3.6, Comment 1. Now, here's a little thing. If you just happen to be getting into law school, or I'm just going to, you ever use like a drop, that's called a drop quotation. You're supposed to use it whenever you have 50 words or more. Don't ask me how I know that, but I do. It's called Blue Book Citation. And as you can see here, Mr. Steele got, he left his double space on. And you know how I know he left his double space on? Because you see that extra space right there? Mr. Steele did not want to change it to the single space and then bring up the citation sentence up one space, which is actually what you're supposed to do. You're supposed to bring it up one space. So that what's called drop quote there, or block quote, which is supposed to be used 1 inch and 1 inch in. and then you're supposed to bring up the little space here by 1. It's supposed to be single space. And then also, this is a full citation where it should be like RPR 3.6 CMT number 1. Hey, Word is hard. I'm not criticizing Brian Steele, but I'm just saying I know what he did there. If I know what he did, because Word is hard. And switching it back to single space, which is what you're supposed to do, it's supposed to be right up on the block quote. Anyways, moreover, comments 5A and 5B delineate certain subjects about which a lawyer could speak, which are more likely to have a material prejudicial effect on a proceeding, and those subject areas are more likely than not to have no material prejudicial effect on a proceeding. I'm going to reread that one, guys. So if you're ever in law school, this is one thing that I've done it before many times, but I'm going to read that out loud again. Moreover, comments 5A and 5B delineate certain subjects about which a lawyer could speak, which are more likely to have a material prejudicial effect on a proceeding, and those subject areas are more likely than not to have no material prejudicial effect on a proceeding. So, guys, if anyone can interpret that. No, a material effect, what that means is important or decisive. Material meaning important, decisive, weighty. In a criminal case, comments which are more likely to have a material prejudicial effect on a proceeding include subjects relating to 1. The character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation or witness, the identity of a witness, or the expected testimony of a party or witness. 2. The possibility of a plea of guilty to the offense, or the existence or contents of any confession, admission, or statement given by a defendant or suspect, or that person's refusal or failure to make a statement. What is more relevant to the issue at hand is the commentary relating to those subject areas which are more likely than not to have no material prejudicial effect on a proceeding. These subject areas include. So look, what Brian Steele here is saying that the things that he's talking about in public, or that the co-defendants or the co-defendants counsel, to be more accurate, what he's talking about is that the co-defendants counsel are not making materially prejudicial statements to the media. And that's fleshing out that argument. So, these subject areas include 1. Information contained in a public record, or 2. The scheduling or result of any step in litigation. So, obviously, I'm a commentator here in Nueces County, Texas, and I'm commenting on a case in Fulton County, Georgia. So, what he's saying is that by me, for example, I'm a member of the public, and I'm reading a motion that's filed in the public record, that me, lawbyreece, and then we've got other commentators, the public commenting on Young Thug's trial should have no material prejudicial effect on the trial, because you're reading from public records. This is a public record. So someone like me from Texas can sit here and read this motion. I don't have to be from Georgia to read this motion and talk about it. That's a public record. Or 2, the scheduling or result of any step in litigation. So it's talking about like discovery, that sort of thing. Any step in litigation, from, in a criminal case, from arrest to arraignment, indictment or information, bond proceedings, and then pretrial and trial motions. Those are the steps. Discovery, and then pretrial, trial motions, motions to suppress, that sort of thing. Those are steps in the criminal litigation process. Every factual allegation in the statement made by Mr. Williams' counsel is contained in the public record. So in other words, yeah, I'm talking about it. I'm in the public. I'm in Texas. I'm talking about it. And there you go. So that shouldn't have a prejudicial effect. Specifically, Mr. Williams has repeatedly, in public filings, as well as by and through his counsel in open court, maintained his innocence. Mr. Williams filed motions for speedy trial. The recused judge. So there's a little bit of a typo here. It should say Mr. Williams filed motions for speedy trial, semicolon, judge recusal or recusing of the trial judge. Lawyer Love and Lawyer Hilton have been accused of and found to have run afoul of their duties under the law, and Judge Glanville has been recused and disqualified from his role as trial judge based on a motion brought by Mr. Williams. Now you have to understand, obviously Mr. Williams himself, Young Thug, is not writing this motion. Brian Steele's writing this motion, and that's a little bit of a slap. It's just sort of an open, slap. I don't know how else to put that. It's kind of a slight. As this honorable court is aware, Mr. Williams' trial is televised live from gavel to gavel. The coverage is available to the public at the click of a link, even when not watched live, as recordings are maintained on www.youtube.com. So he didn't want to actually cite to the specific link, but it's on YouTube. Thus, the likelihood that Mr. Williams' counsel's repetition of information in the public and or findings of the court could materially prejudice an adjudicative proceeding in the matter is absurd. It's absurd. It's crazy. It's wild. Just unbelievable. All right, guys, I'm going to take a quick pause here as we get to section cap number 2. I'll pause the recording and get back to it. I love reading these motions a lot. I don't know. I'm geeking out on this. Gives me something to do that I like a lot. Oh, it's absurd, guys. It's absurd. Absurd. Okay. Moreover, the jurors in the case have been provided cautionary instructions and admonitions countless times, at least daily over the 100-plus days of trial, not to listen to anything related to this case. So, I love starting a sentence with so. So, unlike pretrial comments, which the state is guilty of making. Guilty. The state is guilty. I don't know who tried them, what jury tried the state, but it's guilty, guys. The state is guilty. You see the framing here? The state of Georgia, it's guilty. I like that. It's a little more sharply pointed than yours true would probably put it, but I like it. There is no basis for Mr. Williams' counsel, which is Brian Steele referring to himself, to believe that his statement will have a substantial likelihood of materially prejudicing an adjudicative proceeding. Now, the reason why he keeps saying materially prejudicing an adjudicative proceeding is that is probably the statutory or the rules of ethical conduct. That's probably the statutory language in Georgia, materially prejudicing an adjudicative proceeding. So that's why he keeps saying that. It's quite the tongue twister. Okay, guys, I'm going to take a quick break here. You shouldn't notice this. I'm just clicking pause on my OBS, and I'll be back for more commentary as we get through this motion. Okay, guys, welcome back. I know that I just paused the recording, so it's going for y'all, but I took a little pause. Okay, guys, item number 2. Adoption of Mr. Stillwell's and Mr. Kendrick's motion for mistrial only if this honorable court finds that Mr. Williams was goaded into moving for mistrial based upon prosecutorial and judicial misconduct, and thus retrial is barred. Footnote number 3. Mr. Williams does not join in Mr. Nichols, who's a co-defendant, motion for mistrial without double jeopardy protection. So, guys, if y'all are not aware of this, if double jeopardy applies, that means that Mr. Williams or Young Thug cannot be retried for this same crime. All right, I think that's Sixth Amendment protection on double jeopardy. So if jeopardy does not attach, the state could just re-indict and refile the case. So there's not a whole lot of point in that. The jeopardy really needs to attach. All right, let's continue on here, guys. Mr. Williams has been forced to remain in custody while the recused judge and lawyers Love and Hilton violated Mr. Williams' right to a fair trial, fair tribunal. I feel like fair trial and fair tribunal, like the same thing. Right to due process, right to confront witnesses, and y'all should see the, if you want to see the big case on right to confront witnesses, the case that you're looking for is Strickland v. Washington. Causing Mr. Williams to be goaded into moving for a mistrial as demonstrated by a few examples as follows. 1. Mr. Williams was denied his constitutional right under the Georgia Constitution and federal Constitution to be present at critical stages of his proceeding. See Exhibit A, which is transcript of an ex parte hearing in chambers dated June 10th, 2024, attached here too. The recused judge, he's no longer the Honorable Judge Glanville, he's just the recused judge. I like that. I shouldn't say I like that. It is what it is. The recused judge meeting with sworn witnesses Mr. Copeland was a critical stage of the proceedings in which Mr. Williams and his counsel had, as a matter of law, the constitutional right to be present. See Scudder v. State, 298 Georgia 438-2, volume 782, Southeast 2nd, page 638. Okay, so guys, that's what's called a citing two different reporters. Now, guys, he doesn't have his page number. He's just citing the whole case. That's not a pinpoint citation, Mr. Steele. I need a pinpoint citation. Okay? I'm going to be reading out to the good people here. I need a pinpoint citation. All right? You got to tell me the page number that you're looking at, sir. In the case at bar, which is a very old-fashioned way of saying here, in the instant case, in the case at bar. The recused judge, lawyer Love, and lawyer Hilton. I like how he says lawyer when I say attorney. Attorney Love, attorney Hilton. I prefer attorney. Unlawfully influenced Mr. Copeland to testify against Mr. Williams. See Exhibit A, specific transcript pages referenced in Exhibit B, joint affidavit of Brian Steele and the Honorable Keith Adams Esquire. The Honorable? I guess he was a former judge. Attached here too. Under the federal Constitution and Georgia Constitution, Mr. Williams was prejudiced by being wrongfully excluded from this critical stage of the proceedings where Brady evidence, judicial misconduct, and prosecutorial misconduct were, that's a typo there, were captured and intentionally concealed from Mr. Williams and his counsel. And then footnote number 4 here reads, unlike the federal constitutional provision, the violation of the criminally accused right to be present under Article 1, Section 1, Paragraph 12 of the Georgia Constitution is automatically cause for reversal of any conviction and sentence regardless of any showing of prejudice. See Sammons v. State, 279, Georgia 386-2. That's 612 Southeast 2nd, 785, 2005. Regardless, great prejudice has been caused by the recused judges, lawyer Love's and lawyer Hilton's misconduct as a witness was influenced to testify against Mr. Williams. Brady evidence was hidden. The trust in the court is irreparably damaged and the like. Not only is it irreparably damaged, but and the like. And the like. Similarly. Okay. The recused judge violated Mr. Williams' constitutional right to confront prosecutorial misconduct when lawyer Hilton introduced a known void, null, invalid, involuntary. I like Brian Steele's going off here. So when Brian Steele was typing this, he was going like this. And he was pissed. And he was writing, he said, all right, adjectives, multiple adjectives. Sorry. All right, we're reading on. Introduced a known void, null, invalid, involuntary. Oh, Mr. Steele. Guilty plea before the jury. Specifically, lawyer Hilton elicited testimony from Detective Raisi about an invalid, involuntary. Invalid, void, and involuntary. Guilty plea, knowing that the same does not exist under law to push the prosecution's invalid theme that Mr. Winfrey was protecting the supposed / purported gang members now on trial in the case at bar, meaning this case. The recused judge, yeah, see, he doesn't want to say the Honorable Judge Glanville anymore, no. Mr. Steele was the recused judge. That's all Glanville is now to Mr. Steele. He is the recused judge. He's not the Honorable Judge anymore. He's now the recused judge. Which is factually accurate, but when you repeat that, same statement 45 times, I think you're trying to make a point. The recused judge refused. See, sometimes, guys, if you're writing a motion, you need to read it out loud. You know, you get little things like, the recused judge refused. Now, that's a tongue twister. The recused judge refused to permit undersigned counsel, Brian Steele, to confront Detective Raisi and prove that lawyer Hilton was eliciting non-factual and knowing misleading testimony to the petite jury. This denied Mr. Williams his constitutional right to cross-examine witnesses, constitutional right to a fair trial, and constitutional right to a fair tribunal. Lawyer Love. Now, see, there's a good rhymer right there. Lawyer Love. I like that. Not attorney love or counselor love. Lawyer Love. Lawyer Love has attempted to demonize counsel for Mr. Williams, speaking about Brian Steele writing about himself. Counsel for Mr. Williams, as well as the other accused counsel in front of the jury. This appears to potentially be Lawyer Love's standard practice. See Exhibit D, the appeal. Medical staff at notorious Atlanta jail let autistic teen waste away and die, lawsuit says, pages 6 through 7. Now, guys, do you see how that 6 through 7 there is a little small size dash? I know this is going to sound crazy, that should be an EN dash or an N dash. It should be a mid-size dash because that's 6 through 7. Attached here too, prosecutorial misconduct has been perpetrated by Lawyer Love. And that's a passive sentence. Lawyer Love perpetrated prosecutorial misconduct. Anyways, prosecutorial misconduct has been perpetrated by Lawyer Love from the inception of this case in order to goad Mr. Williams in moving for a mistrial. All right, guys, section number 5, and this thing goes on, good Lord. These are all exhibits. Okay, I just want to make sure. I don't want to read every, oh boy, that's a lot. I don't think I'm ever getting through all those exhibits. That's something. Okay, let's get back to where we were before. Lawyer Love and Lawyer Hilton will be called as necessary witnesses in this trial by Mr. Williams, as material conversations with sworn witness Copeland are not captured on the transcript of the June 10th, 2024 unlawful ex parte meeting. See, for example, Exhibit A, page 22, lines 3. That's it again. That should be a little N dash. Not a hyphen, an N dash, E-N dash. There are 3 dashes. There's the little tiny dash, there's the N dash, and then there's the M dash. And the M dash is for like when you're breaking up 2 separate sentences. The N dash is for through, to or through. So that should be the mid-size dash. All right, the recused judge violated. All right, we've talked about that. Lawyer Love, yeah, we talked about that. All right, guys, section number 5 here. The above few samples prove, in the event of any wrongful conviction of Mr. Williams, comma, there is a substantial likelihood of reversal by an appellate court. See, that sentence is not quite right, Mr. Steele. That should say, the above few samples prove, in the event of any wrongful conviction of Mr. Williams, comma, it should be that. The above few samples prove, comma, that in the event of any wrongful conviction of Mr. Williams, he's missing a that. And then, or you could have done a colon here. So one sentence and then announcing the next sentence. There is a substantial likelihood of reversal by an appellate court, including a court presiding at a motion for new trial. Therefore, the continued incarceration of Mr. Williams is punitive without legal justification. This past month and a half alone finds Mr. Williams helplessly trapped in a cell based upon the intentional misconduct of lawyers Love and Hilton and the recused judge. This delay in causing this honorable court to parachute into the case has infringed upon Mr. Williams' freedom. Respectfully, bond must be granted. This continued incarceration of Mr. Williams is unconscionable, as has much of this, quote, trial, end quote, under the guiding hands of the recused judge. And he's no longer the Honorable Judge Glanville. I mean, how many times are we going to say the recused judge? It's strong. This continued incarceration of Mr. Williams is unconscionable, as is much of the lawyers' love in Hilton. The prosecutors and recused judges' misconduct and trampling, that's an active verb right there, of Mr. Williams' constitutional rights has forced Mr. Williams to timely move for several mistrials after being goaded into same. This, quote, trial is not fit for a kangaroo. Oh, man. Mr. Steele, that's something to put in your motion. Oh, boy. That's something that I was not expecting to find in a court filing, but this, quote, trial is not fit for a kangaroo. Not something that I would put in my motion necessarily, at least not at this point in my career, but I get it. It's strong. This trial's not fit for a kangaroo. Number 6, Mr. Williams lawfully filed a statutory demand for speedy trial. No reasonable person would argue that a speedy trial has been satisfied. For example, the recused judge ordered Mr. Williams to be held in custody without bond since May 9th of 2022, while over 2,000 potential venire panel members were mostly individually voir dired for, quote, hardship. There was no valid reason to summon over 2,000 potential jurors, since the petite jury was selected from the first 511 jurors who were all summoned to the courthouse on January 4th, 2023. Undersigned counsel will be inquiring of the recused judge as to the reason that Mr. Williams had to endure suffering in custody, months of unnecessary individual jury hardship questioning. This unnecessarily elongated process of, quote, jury selection, end quote, was a waste of time and violated Mr. Williams' constitutional and statutory rights to a speedy trial. This continual waste of time has caused Mr. Williams to be wrongly denied freedom and a fair, speedy, constitutional sound trial. 7. Mr. Williams has given reasons for bond to be granted. See renewed motion for bond filed on July 23, 2024. In order to be released from the unlivable, inhumane conditions of the county jail that he has wrongly endured since May 9, 2022, Mr. Williams has offered conditions of bond to include release with 24-hour surveillance by law enforcement. While Mr. Williams is not a significant risk of flight or a significant threat to others or the community, and thus does not need law enforcement to surround him, he has, however, offered this extreme provision if this honorable court wishes to apply that condition. However, under all circumstances, a pre-verdict bond must now, respectfully, be granted. The past will never be forgotten, but Mr. Williams' improper detention and unlawful suffering must end. Number 8. Furthermore, counts of this indictment failed to allege at least one essential element of the crime. Thus, there is a fatal variance and jeopardy has attached. Thus, see, there too many thuses, Brian, okay? Thus, comma, there's a fatal variance and jeopardy has attached, thus. All right, we needed to proofread this for how many thuses there are. Okay. This case can never be retried and should be dismissed at this time, as a general demurrer can be filed at any time. Just so y'all know, what general demurrer is not allowed in the state of Texas, but I suppose it is in, well, not in civil practice at least. The recused judge denied this timely filed plea in bar / motion to dismiss / general demurrer, and then denied a certificate of immediate review, and thus the Honorable Court of Appeals of Georgia dismissed Mr. Williams' direct appeal for lack of jurisdiction. Thus, the law, see Exhibit H, Court of Appeals order dated January 19, 2024, see Exhibit I, order denying Jeffrey Williams' plea in bar / motion to dismiss / general demurrer attached hereto. Thus, the law of the case doctrine does not apply, and Mr. Williams asked this honorable court to decide this general demurrer issue, so this case or counts thereof can lawfully end instanter. Instanter meaning right now, instantly. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, asks this honorable court to grant the above requested relief. And then it's signed Brian Steele and Keith Adams. And then we get into the exhibits. Okay, so I wanted to give you my thoughts on this motion before I end this video. This video's gone on about 50 minutes. Although, you know, we might go into... I don't know. Should I keep going here? All right. 1 hour ago, Thug's lawyer has filed a motion with multiple purposes. Respond to motion to forbid defense from talking about case to media. Adopt motions for mistrial with no retrial from other defense lawyers. Specifically, not join Harvey's mistrial motion without double jeopardy. And then here we can see an image of... This is a song. I cannot play it, but this is a song. That's an image of Mr. Williams. Lawyers for Yak Gotti have responded to the state's request to forbid defense attorneys from talking about the YSL case in the media. This is 8 hours ago. And it starts out quoting Fulton DA Fannie Willis doing just that. So here we have in the Superior Court of Fulton County, state of Georgia, this is the state's motion to restrict extrajudicial statements. And let's have a read of this. This was filed July 23rd, 2024. All right, guys, so we see the state's motion to restrict extrajudicial statements. Comes now the state of Georgia and moves this honorable court to instruct the defense to refrain from making further extrajudicial statements about this case moving forward. Georgia Rule of Professional Conduct Rule 3.6 prohibits lawyers participating in litigation from making extrajudicial statements a reasonable person would, quote, believe to be disseminated by means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. And that's footnote number 1, Georgia Rule of Professional Conduct 3.6 sub A, paren A. A relevant factor in, quote, determining prejudice is the nature of the proceeding involved, with criminal jury trials being, quote, the most sensitive to extrajudicial speech. The character, credibility, reputation of a party, and quote, any opinion as to the guilt or innocence of a defendant are subjects deemed to be more likely to have a material prejudicial effect on a criminal proceeding. Defense counsel have made numerous extrajudicial statements explicitly about this case while a jury is sworn and seated during the state's case in chief. Defendant Williams' counsel, attorney Brian Steele and Keith Adams, defendant Kendrick's counsel, attorney Doug Weinstein, and defendant Stillwell's counsel, attorney Max Shart, have all made extrajudicial statements to the media explicitly discussing this case in violation of Rule 3.6. The extrajudicial statements have included, among other things, that, see, even the state's attorneys, see, guys, they're not all perfect. That should have a comma right there. Included, comma, among other things, comma, hello, or inter alia. Interviews and statements to the Associated Press. 4 of those interviews have been 25, 33, 43, and 107 minutes in length. The statements include, among other things, the attorney's views and opinions about the case itself, opposing counsel, the, quote, now former judge, the jury, the outcome, and the guilt or innocence of specific defendants. Pursuant to OCGA Section 15.134, courts have the power, quote, to control in the furtherance of justice the conduct of its officers and all other persons connected with the judicial proceeding before it in every matter appertaining thereto. The state thus moves this honorable court to instruct the defense to refrain from making extrajudicial statements about this case moving forward. And then we see here an Adobe Acrobat signature. And that's Adrian L. Love, Chief Deputy District Attorney, Fulton County District Attorney's Office. And then Thugger Daily wrote, the state has asked the judge to prevent the defense attorneys in the YSL case from talking about the case outside of court in the media. All right, so we've got another motion here that I'd like to get through, guys. This was filed July 26, 2024 in the Superior Court of Fulton County, State of Georgia. State of Georgia, plaintiff v. DeMonte Kendrick, defendant. Kendrick's opposition to state's motion to restrict extrajudicial statements comes now. And guys, I'm going to be honest with you. I don't like comes now very much. My legal writing professor didn't like comes now very much, and so I don't like comes now very much. Where else are you going? Are you going somewhere else? Are you filing a motion to someone else? Do you think that we can't read and that we don't know it's you talking? I don't know. I don't like comes now. It's very archaic. I don't like it very much. Well, who else is coming? Okay. Comes now, defendant DeMonte Kendrick in the above styled case. In opposition, in the above styled case. What other case would you be talking about? Where are you going? And what other case are you talking about other than the one that is listed above in your stylus? So I have to agree with my legal writing professor that it's just, why? In opposition to the state's motion to restrict extrajudicial statements, showing the court the following, quote, everyone is in favor of free speech. Hardly a day passes without its being extolled. But some people's idea of it is that they are free to say what they like. But if anyone says anything back, that is an outrage. Sir Winston Churchill. All right, so I see that we have a number of quotes here. And then, quote, I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not targeting anyone. You do not get to commit crimes in my county and then get to decide to brag on it, which you do that for a form of intimidation and to further the gain and to not be held responsible. The Honorable Fannie Willis, Fulton County District Attorney, press conference of August 29, 2022. Are you supposed to address the district attorney as the Honorable? I've never heard that. I've never been told that you have to address the district attorney as the Honorable. That's a first for me. I'll be honest with you. I've never seen that. You're supposed to address the court, as in the judge, as the Honorable, but I don't know who says that the district attorney is supposed to be so honorable. It's just another attorney representing the state. Maybe that's something that I just missed in law school, but she's an elected official. I don't. So are judges, but I've never called a district attorney the Honorable. I guess that's what you're supposed to say. If you decide to admit your crimes over a beat, I'm going to use it. That's not right. That's just not right. In all seriousness, I'm not pro-crime, but I don't think that song lyrics should be used in your criminal trial. We all make songs and music about things which, well, we don't all make, but who is to say or who is to prevent you from making song lyrics about things which you might not actually do? I don't know whether these defendants actually shot anyone or engaged in organized crime. I know that they're presumed innocent until proven guilty, innocent unless proven guilty. And so I don't like that at all. I'm not very pro-state, and I don't like your speech, whether it's in music or in poetry or in lyric or in writing. I don't like that there are rap or song lyrics. I don't listen to this guy's music. I have no interest in listening to this guy's music. I don't care whether it's a recounting of factual events or not. I don't think that should be used as evidence in the prosecution of a RICO trial. It just seems wrong to me. I don't think that should be admissible evidence, and I don't think that's a good and fair statement. I'm not targeting anyone. Well, you're listening to music and then you're targeting that artist. Free speech for me, but not for thee, is the current position advocated by the Fulton County District Attorney. This should not be surprising to anyone that has paid attention to the present case over the last 19 months of trial. The state would apparently like the present trial to be conducted in secret, with proceedings happening in hidden chambers outside the prying eyes of the press and the public. Guys, I think this defense attorney is totally right. We have a right to a public trial. Public trials. Trials are supposed to be conducted in the public eye. We have in Texas we have a very strong presumption of that, and I believe that they have a similar statute in Georgia. We have a very, very strong presumption of public trials here in the state of Texas, and I think it's the same way written statutory language in Georgia. And yeah, the trials should be public, guys. These are public proceedings. And of course, the state, which continues to try and gag the defense and trample all over the defendant's constitutional rights. I am a fan of procedure. There is a process by which we convict criminals. They are presumed innocent unless proven guilty. And they are clothed in that innocence unless proven guilty. And trials are public. Trials should be public. Proceedings should be public. And you should be allowed to make the rap lyrics that you want to make and not be prosecuted by your district attorney for rap lyrics, okay, for artistic expression. And that's not to say that I'm pro-crime. I'm not pro-crime, but I am pro-Constitution. Okay. The state has repeatedly sought the secreting of witnesses' identities, even in instances where the state has made no showing of risk to the witness, despite this court's order that such showing be demonstrated prior to blocking the broadcasting of witness testimony. After attacking the integrity of respective counsels for defendants and witnesses, for example, repeatedly calling the Honorable Brian Steele a liar and the Honorable Jonathan Melnick of working for defendants. I don't like this whole calling other attorneys the Honorable. That's really reserved for the judge. Calling the Honorable Brian Steele a liar. It should be Attorney Brian Steele or Lawyer Brian Steele, but I prefer Attorney Brian Steele. Counselor Brian Steele. I don't like the Honorable. He's a lawyer. We're not also honorable. Accusing the Honorable Jonathan Melnick of working for defendants rather than his client, Kenneth Copeland, the state now turns its attention to counsel for DeMonte Kenrick. But to paraphrase President Truman, counsel does not give the state hell. Counsel just tells the truth about them, and they think it's hell. In a 1.5 page motion, the state cites to Rule 3.6 of the Georgia Rules of Professional Conduct and cherry-picks certain comments to the rule to support its motion to, quote, instruct the defense to refrain from making extrajudicial statements about this case moving forward, end quote. No case law is cited. No finely tuned order is proposed. As the state accurately quotes, Rule 3.6 bars lawyers from making extrajudicial statements that a lawyer knows or reasonably should know have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. The state provides no specific quotes of Kendrick's counsel that might be barred by Rule 3.6. Instead, the state invites the court to go on a scavenger hunt among 208 minutes of interviews to find statements by Kendrick's counsel that might arguably violate Rule 3.6. The court should decline this invitation. Remarkably, the state does not make a single argument that any statement by Kendrick's counsel meets any of the elements of Rule 3.6. They're not elements. I guess, elements of a law. It's not a law. Instead, the state simply offers up a single conclusory statement. There is no argument that any statement made by Kendrick's counsel was known to or should have been known to have a substantial likelihood of materially prejudicing this jury. No argument was made because no argument can be made. The present jury had been impaneled and hearing testimony for months before any statement was made. The jury has been instructed at the conclusion of every day of trial by Chief Judge Glanville through his, quote, ad nauseum admonitions to not discuss the case with others or with each other. Ad nauseum admonitions. They have been instructed daily not to consume, to not, see guys, these split infinitives, it's not to consume. That's proper English, not to consume. Okay, it's not trail, it's trial, and it's not to consume. Daily, to not consume any media about the present case. I don't like that split infinitive, sir. No statements made by counsel for defendants can be heard by the jury to prejudice the jury. The state invites this honorable court, which is trying to catch up on hundreds of orders, many of which are provisional, 19 months of trial, over 100 days of testimony, and testimony from almost 100 witnesses, to wade through hundreds of minutes of interviews, find statements of Kendrick's counsel that might be objectionable, determine what Kendrick's counsel knew or should have known, and summon a reason about why and how they could materially, meaning the statements, could materially prejudice a jury that is barred from and admonished on a daily basis from consuming media about the present case. This honorable court should respectfully decline this invitation. In addition, the state conveniently fails to quote from the presumptively safe harbor comments included in Rule 3.6 that permit Kendrick's counsel to speak in public on his behalf. Comment 5B(a) reads that, quote, there are certain subjects which are more likely than not to have no material prejudicial effect on a proceeding. Thus, a lawyer may usually state information contained in a public record. Each statement made by Kendrick's counsel relates to publicly available information in the public record of the present trial, which is being streamed daily to the public. To the extent there are any remarks not specifically in the public record, such statements are general remarks intended to demonstrate that Kendrick should not be on trial. Justice Kennedy rightfully understood that the present situation that Kendrick and his counsel find themselves in. Kennedy wrote that an attorney's duties do not begin inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for the client. An attorney may take reasonable steps to defend a client's reputation and reduce the adverse consequences of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives. A defense attorney may attempt to demonstrate in the court of public opinion that the client does not deserve to be tried. That is Gentile v. State Bar of Nevada, 501 U.S. 1030 at 143, 1991. See, that's a good pinpoint site. We needed that pinpoint site. Mr. Brian Steele didn't have his pinpoint sites. Okay. Justice Kennedy also correctly notes that the police, the prosecution, other government officials, and the community at large hold innumerable avenues for the dissemination of information adverse to a criminal defendant. By contrast, a defendant cannot speak without fear of incriminating himself and prejudicing his defense, and most criminal defendants have insufficient means to retain a public relations team apart from defense counsel for the sole purpose of countering prosecution statements. Id at 1056. Justice Kennedy cites the important role that defense counsel plays in educating the public on pending cases, writing, because attorneys participate in the criminal justice system and are trained in its complexities, they hold unique qualifications as a source of information about pending cases. Since lawyers are considered credible in regard to pending litigation, are we considered credible? Since lawyers are considered credible in regard to pending litigation in which they are engaged and are in one of the most knowledgeable positions, they are a crucial source of information and opinion. To the extent the press and public rely upon attorneys for information because attorneys are well informed, this may prove the value to the public of speech by members of the bar. If the dangers of their speech arise from its persuasiveness, from their ability to explain judicial proceedings, or from the likelihood the speech will be believed, these are not the sort of dangers that can validate restrictions. The First Amendment does not permit suppression of speech because of its power to command assent. This is the exact situation that Kendrick and his counsel find themselves in today. Kendrick is a public figure who is an artist. He writes, records, and performs rap music and lyrics. In Fulton County, this makes Kendrick a target of the state. Kendrick is allowed to take reasonable steps to protect his reputation, and those steps may be taken by his counsel rather than through a public relations firm. Having smeared Kendrick and his reputation, the state wants to silence him, initially by placing a burden on his free speech rights to write about the world in which he lives and the tragedies and injustices around him, and now by holding press conferences denouncing him and his writing, while subsequently seeking to bar him from defending himself in the court of public opinion. While the state has unfortunately been successful in impermissibly burdening the free speech of Kendrick by limiting his present and future writing, the state should not be allowed to bar him from defending his reputation. Wherefore, Kendrick prays that the court deny the state's motion. Okay. And here we go from Thugger Daily. Yeah, this is a music video. Cannot play that. The state has responded to the Young Thug's motion to challenge the factual findings of Judge Krause. They cite the same two cases they cited in front of Judge Glanville to argue that the secret ex parte hearing was proper and argue that the defense didn't have a right to be there. Okay, guys. Well, I'm going to keep you posted here on the Young Thug trial. This is going to be one of many commentaries, guys. I like making YouTube videos, so here we are. Guys, this has been Law by Reese with my first commentary video here on legal matters, guys. I want to thank you for joining me, and please make sure to like, comment, and subscribe.